Um, so hi, hello, and welcome to our first small business webinar in the Modest Means Helpline Small Business Webinar Series. Our presentation today is Business Entity Options in New Mexico. My name is Brecken Larson, and I'm a staff attorney with the Modest Means Helpline. And our co-presenter today is Larry Donahue of Law for Small Business. Larry, do you want to say a few words about yourself?
Sure. I've been an attorney about 30 years, so I'm an old fart, and we do a lot of business around small business for legal services. We compete with the internet companies as well, so we do a lot of formations, and then we try to help out local businesses in the state of New Mexico as well.
Nice. And we're also Casey Daniel. You will see her at the top of your screen as well. She is the Legal Services Director for the New Mexico State Bar Foundation. And Casey will be our moderator during the webinar. If you have any questions, please type those in the Q&A or the chat box. And Casey will periodically pause the presentation and ask your question. And also, if you have ideas for future presentation topics, please type those in the chat box. This is our first of 3 webinars that we will be doing between now and the end of June. So we're collecting ideas on that. Next slide, Casey.
I think we lost her. Oh, no, there we go.
There she is, yeah. So first, we wanted to provide a little bit more details about the Modest Means Helpline. The Modest Means Helpline is a civil legal telephone helpline and attorney referral service operated in-house under the New Mexico State Bar Foundation. The helpline assists New Mexico residents with incomes at or below 500% of federal poverty guidelines. The helpline can assist in civil legal matters, including but not limited to domestic relations, landlord-tenant matters, small business issues, consumer, and probate. The helpline's 2 staff attorneys, Casey and myself, provide legal advice by phone, and if appropriate, we may refer the case to a volunteer attorney for representation ranging from pro bono legal advice to limited or full representation. Those who are interested may reach the helpline at the numbers on the screen. Our main numbers 505-797-6013. And right now our helpline is open Monday through Friday between the hours of 8 a.m. and 1 p.m. And also, really quick, a disclaimer that our presentation today is to provide you with general legal information. The presenters are not providing legal advice or are not entering into any attorney-client relationship with any attendees of the webinar. We won't be discussing specific situations in the webinar, so please refrain from asking fact-specific questions. You can call our helpline with specific questions after the webinar, and if you're eligible, we can go into detail with you. Okay, next slide. So today we will be discussing the basic types of business entities that you can form in New Mexico. And we're going to move through the entities from those that require the least amount of effort to form, or that have sort of the least amount of formalities, to those that require the most effort to form and have the most formalities. And for each of these types of business entities, we'll discuss the structure and risks and liabilities involved, and briefly how to form each of these different types of entities. And just so you know, there's other types of business entities out there and available, and other variations in addition to the variations to the entities you see on your screen. And we won't be discussing those variations in today's presentation. Okay, so next slide, we can go ahead and get started. The first entity that we're going to discuss is called a sole proprietorship. And a sole proprietorship, many people operate a sole proprietorship without even realizing it. This entity isn't specifically provided for under New Mexico statutes like partnerships or LLCs. So basically a sole proprietorship, a couple of definitions we have on your screen. One is from a workers' compensation statutory definition, which says a sole proprietor is a single individual who owns all the assets of a business and is solely liable for its debts and employs in the business no person other than themselves. And then tax and rev, we also have another definition. You are a sole proprietor if you own all the assets of a business and you also assume liability for all debts of the business. You have no partners and you're not incorporated. And so, in terms of formation of a sole proprietorship, there is no formal registration required through the New Mexico Secretary of State. There's no requirement that you file your trade name or your doing business as name. If you are an individual who operates a business, it could be possible that you're operating as a sole proprietorship. And it's important that you understand that you could have certain legal responsibilities like reporting taxes, and in that scenario, and in most of them, we would always recommend that you consult a tax professional like a CPA to understand what your legal responsibilities might be. We also would recommend, as a best practice, that you search the Secretary of State's website online for other New Mexico businesses that might be operating under a same or similar name. And really quick, I can show, Casey, if you'll let me share my screen, I can show you how to search on the Secretary of State's website. Okay, can you see my screen? Yes?
Yes.
Okay. So the Secretary of State's main website is this sos.nm.gov. And at the top, there's a couple ways that you can get to this function. There's a button right here that says Online Services. And if you click on Business Portal, it takes you to a larger business portal that you can create a login for. But what you're looking for is this top button that says Business Search. And here is the box that you can go with, starts with, exact match, or contains generally. And you could search a name, a trade name or a doing business as name that you use, and or to just double check and see if other people might also be using this name to try to avoid some type of dispute. In my past practice, I often saw and or sent some cease and desist letters when businesses were operating using similar names and causing some interruption and disruption. So a best practice to check the Secretary of State's website before you're operating, and just to double check that your name isn't already taken or being used. Larry, do you have anything to add about sole proprietorships?
A couple of quick things. One is, the general rule for sole proprietorship is you're conducting business without under a corporate entity. But even if you have a corporate entity, let's say you formed an LLC, you could still be operating as a sole proprietorship. How could that be? Well, it's because you signed the contract with your landlord under your personal name, not your LLC name, for instance. So sole proprietorship basically means you're conducting business. Now, what's interesting to me, and for any policy makers that are watching this video, I really have a big problem with the state of New Mexico as it relates to how they form some of their rules. And what you see here with the workers, workforce solutions really, and how the workers' compensation works versus tax and rev. Tax and rev department does not establish who's liable to what. Tax and rev simply has its own rules and says, if you're sole proprietor, this is how we're going to define you, and this is how we're going to hold you accountable to taxes, or collecting gross receipts tax, for example. Workers' comp is a whole different thing. They're basically trying to force people to have workers' comp insurance. And that's how they define a sole proprietor, which is clearly different from how New Mexico Tax and Rev defines it. And you have to be careful because it says here, employs no person other than yourself. And when we think employ somebody, right, it usually means somebody on the payroll, but not for workforce solutions and not as it relates to workers' compensation. Employ means it could be contractors as well. 1099 contractors could trigger this. And what does that mean, trigger? It means you're no longer a sole proprietor as far as they're concerned, and you're supposed to carry workman's comp insurance, even though you're just operating as a sole proprietorship. So Sole proprietorships are dangerous in my view. And what it means is you're doing business and you haven't put formality around things. You haven't thought about things. You have a paper route. What kind of trouble can you get into with a paper route? The answer is quite a bit. So I always encourage people, if you're conducting business, formalize it. And we're going to talk about other structures here in a little bit. The other thing I want to mention about looking up names, the best practice, I think that's a great idea, by the way. And the reason for that is we lawyers make money when there's problems. So if you don't do the best practice, you could potentially create a problem. And we lawyers love that because that's how we get paid. Now, there's one rule I want to tell you, though. You're not looking for an exact match. You're looking for similar. And that really gets people in trouble a lot. So similar in look, sound, or meaning. If you're using another name that's similar to somebody else's, you can get yourself into trouble. So if you see a similar name, that might be a hint to talk to an attorney or somebody that might be able to weigh in and give you an opinion on whether there's going to be a potential problem or not.
Okay.
Okay, there was one. There was.
Yeah.
Oh, you guys have a question that I think you kind of answered, but can we still have employees as a sole proprietorship? What is the legality regarding employees?
You want to answer that, Brecken, or you want me to?
Go ahead.
So, I mean, at the end of the day, you can have employees. There isn't a legal implication per se, but you are expected to follow the law as it pertains to employees like a regular entity. So the big problem, though, is if there's an employment dispute, if there's a problem, it's you personally that could be potentially liable for stuff like that versus your entity. So you still have workman comp issues. You're not going to be viewed as a sole proprietor as it relates to workforce solutions and whether you need to get workman's comp insurance, for example, but you'll have all the other issues. You're going to have general liability insurance. You're going to have an employee manual, or at least treat people the same, all the same circumstances, when you have an employee, one or more employees as a sole proprietorship.
Okay.
Any other questions?
None yet.
Okay. So moving on to partnerships. So similar to sole proprietorships, many people can operate a partnership without realizing it, that they're operating a business entity already. A partnership, by definition, under the state statutes, is an association of two or more persons who carry out as co-owners a business for profit, whether or not they intend to form a partnership. And persons is defined a few different ways under the statutes. It can mean an individual, a corporation, another type of business entity like another partnership or another LLC. So has a bit, it's on the end of informal in terms of registering and being able to operate. Partnerships, the at least two persons that are acting as partners of the business, each partner has an equal share in the profits of the business and also an equal responsibility for the losses and debts of the business. Each partner has equal rights in management of the business, and each of the partners also owe fiduciary duties to the partnership. Those duties are the duty of, for example, the duty of loyalty and the duty of care. Some further examples of that are, refraining from dealing on behalf of, on behalf of the partnership, or on behalf of a party who has an interest that's adverse to the partnership, refraining from competing with the partnership, dealing with an obligation of good faith and fair dealing. That kind of gives you an idea of fiduciary duties. In addition, each of the partners can act as an agent of the partnership, which means that they can sign documents, they can carry out the ordinary course of the partnership business, and they can bind the partnership. So they can, bind the partnership for certain financial commitments, other commitments, each partner alone. That's sort of the structure of a partnership. The risk and liability involved with a partnership is that each partner is jointly and severally liable for all the obligations of the partnership. So it could be found that one of the partners as an individual is responsible for the whole of the obligation or the whole of the debt. Just that one person can individually be held from a personal liability standpoint. The partnership itself can also be, the entity itself also has a bit of liability that could be sort of imputed onto the entity. And that would be for loss or injury that's caused to a person that's a result of a wrongful act or omission of a partner who's acting in the ordinary course of the business and with authority for the partnership. Before we go to the next slide, Larry, anything to add on these topics for partnerships?
Oh, yes. You want the 1 minute or 5 minute overview? Somewhere in the middle.
Just, yeah, go for it.
So the big issue with partnerships is I like to say ad hoc or de facto partnership, and they're very dangerous. And especially with some of the folks here on the call who deal with startup entities, organizations, people, all it takes is two people to say, hey, this sounds interesting. And then they start working in furtherance of the enterprise. That could just include going to the library and doing research. The moment that happens, de facto partnership. Or somebody can argue that. Who can argue that? Well, maybe heaven forbid, the parent of the child who got hit by your partner's car going to the library because they were going to do some research on the company. You're potentially on the hook for that, even though you didn't ask your partner to go to the library and do any research, or you told your partner that you weren't interested in working with them and they wanted to do it anyway. The other person that can make an argument is the partner themselves. And we're seeing a lot of these issues right now with cannabis-related businesses where a bunch of people get together and they're like, hey, let's start up a cannabis business. And then sure enough, one or two of the friends falls off. They don't do anything further, but maybe one, two, or more people do go further. And then 6 months, a year later, those old partners that fell off are now coming back arguing, hey, this was a partnership. We were a part of that, and we want our check, please. Thank you very much. And so that's why I call partnerships very dangerous. You want to try and keep people, yourselves, from entering into these partnerships at all costs. And you want to formalize them if you can, or at least have some sort of documentation that there is no partnership. Final issue is we have agents here. And what it means is a parent agency can create problems. And so if somebody does something in furtherance of the business, even if you tell that person not to, if they're an agent of your company on the payroll, they're a partner, something, you can get into trouble and you can get into liability, even if you told them specifically not to do the action they did that caused the harm. You're still in trouble. So the law of agency can create all kinds of problems for partnerships, which is why I strongly discourage people from entering into them if they are, and instead formalize it with an LLC or something like that.
I wanted to jump into that maybe the example of sort of also understanding joint and several liability would be if the partnership is sued and both of the partners were named in the lawsuit, and that ultimately, if a judgment was entered against the partnership, the opposing counsel could be looking at how they're going to collect. And so when thinking about being jointly and severally liable for the debts of a partnership, if the winning side of the lawsuit isn't able to fully collect or fully be made whole by one of the partners, they can shift and go to the other partner to try to fully collect on that judgment.
And that's a really great point. You need to know, sorry for the crude analogy, who you're going to bed with, right? If you are partnering with somebody of limited means, you could potentially be on the hook, even though you're sharing the potential responsibility. So you need to be really careful with what you're doing. And there's a question, by the way, Lindsay had a question.
Yeah.
You want to read it out, or you want me to?
Go ahead.
What if you haven't made any profit as a business yet? Do you want to take that or you want me to answer?
So it's like you've been operating, but you haven't technically been, And so the question being, are you still in a risk? What's your risk liability level? Is my guess, is what Lindsay's asking.
That would be my guess.
I mean, I'm trying to fill that in a little bit, but I guess I'm thinking, well, just because you haven't made any money, if you're operating, if you're signing loan document, you may still be taking these actions and incurring sort of, or exposing yourself personally or as a partner. You still may be taking actions that could have adverse consequences. I'd say you're still, if you're existing, what would you say, Larry?
Yeah, no,
You're
Becky,
still,
you're absolutely right. I would phrase it as follows: irrelevant how much money you're making or how much profit you have. Irrelevant. If you are operating at all, you have issues. And if you're collecting money, you have issues, whether you're making a profit or not.
So there's another question, but I think it might be fact specific. It's what business model should I use? Making jewelry and have invested in tools and have made some items, but not enough to cover expenses.
You want me to tackle that or you want to do it, Brecken?
do you want to, let's see if we have time at the end, maybe after we've gone through all the entities. And then also if we don't have time, Lindsay, please do call our helpline as well.
Yeah, I think that's
okay.
good.
Okay, so next, we do have one more slide on partnership. Again, just to sort of reiterate what we mentioned, it's a very informal formation of a partnership. It's the association of two or more persons who carry on as co-owners for profit, whether or not they intend to. So partnerships are governed and structured under New Mexico law. There are state statutes that at least contemplate partnerships. And the statutes will govern the topics that are on point within the statutes, unless you have, which again, another recommended best practice would be that if you do choose a partnership, that you formalize the obligations of the partners and the operations of the business through a partnership agreement, a written, signed partnership agreement, rather than relying on the statutes to guide you in moments of probably some type of dispute or conflict. And then again, registration with the Secretary of State for partnerships is optional. It's not required at this point, just still a part of that informal formation of a partnership. Larry?
I thought that was great. Nothing, I could go on and on and on, but I thought you were great.
Okay. Okay. So next slide. Okay, great. Next slide, limited liability companies. So now we're shifting to a new entity that on the spectrum of this does start to become something that in these types of entities take much more effort to form and have a few more formalities. Limited liability companies, from a structure standpoint, can be structured in several ways. You can have a single member or a sole member that makes up your limited liability company. A member can be an individual. It can be another type of entity. It can be another LLC. It also includes, in New Mexico, a husband and wife that are operating can be considered as a single member for formation purposes or structure purposes. It could also be a trust. So the trustee of the trust being the single member. A limited liability company can also be structured as a multi-member limited liability company. And again, those multi-members can be individuals. They can be other types of entities. If this is sort of a general statement, but if you are going to have a multi-member LLC where there is some type of anticipated investment structure, or there are going to be investors in the multi-member LLC, we recommend that you seek legal counsel, seek legal advice from an attorney who specializes in securities law in that instance. From a management standpoint, the structure of a limited liability company, it can be considered member managed or manager managed. That's sort of it's an either or there. And the limited liability company can also designate officers to carry out the management or have certain authority roles to operate the LLC.
Got a couple questions. I don't know if you want me to tell you them.
Okay. We're on the first of a few slides of LLCs. Do you want to hold them?
Sure, we can hold. Yeah, we can hold. So now there's a third one. So I think these might be answered through your presentation. So I'll just wait and ask them all at the end.
Okay. Larry,
anything? One thing I want to mention about the investors. This statement here, seeking a securities lawyer, is not unique to LLCs. If you're thinking of investors, period,
that's true.
Proprietorship, anything, talk to a securities lawyer. And the reason you need to do that is if you make a mistake, you don't get a slap on the hand. You could go to jail. This is serious stuff. You could look up blue sky laws and SEC stuff. You don't want to be messing around with investment and investors without talking to a professional.
Okay. Risk and liability from a limited liability company perspective. One of the major benefits of an LLC is that the debts, obligations, and liabilities of the LLC are solely the debts, obligations, and liabilities of the LLC to a certain extent. So managers can also, if you are manager managed or you have a manager of the LLC, they could be held potentially liable for acts or omissions that deal with gross negligence or willful misconduct. The members of the LLC could also be held potentially liable for any written promise to contribute cash, property, or render services. And then overall, there's a concept called piercing the corporate veil, where if an LLC is sued, or if a lawsuit is brought against an LLC, and there are facts to support a court piercing the corporate veil, so looking beyond the sort of shield that members benefit from in terms of protection, and going after based on certain bad actions of a member or a manager or an individual person that's operating the LLC, that the court can use this concept of piercing the corporate veil to try to impute that liability and go after the individual to recoup the damages or pay the damages or hold them responsible, I guess, hold the members responsible for the actions that they took if justified. In terms of voting, so limited liability companies, if it's not otherwise provided for in an operating agreement, the law supports that members vote, if there's more than one member, in proportion to the value of their contribution of capital to the company. Similarly, with the sharing of profits and losses, if it's not otherwise provided for in either the articles of organization, which we'll talk about next, or an operating agreement, then the sharing of profit and loss under the law, sort of the floor, the default would be in proportion to the members' contributions of capital. And capital being, that can be funds, that can be property or services, as could be set forth in the operating agreement. Larry?
Oh, yeah. So a couple of quick things here. One is piercing the corporate veil. Just quickly, it's generally some sort of wrongdoing, but it involves not following corporate formalities. So that means you downloaded a template operating agreement off the internet, didn't read it, and don't even care about it and just do whatever. So you don't want to do that. Or, if you download something off the internet, you got to read it and manage your business to it. And another one is commingling. So Now, there's a few others, but those are the two biggies. And commingling means sharing resources with yourself or other companies. So you want to avoid doing that. And so how do you get money into a company if it has no money, but it needs to hire lawyers, for instance? The answer is you can, don't write the check yourself. Write the check to the company deposits it in its bank account, then it pays vendors or so on. And what is that money? It could be a loan, it could be a capital contribution. Your accountant will help you figure that out. But don't write checks for business expenses with personal checks, and vice versa. Don't have the company pay your mortgage or your cell phone bill. The company can pay you correctly through a salary or distribution or something like that. Again, your accountant can dictate that, but don't have the company be paying your personal bills. Those are great ways to get yourself into trouble.
Okay, forming LLCs. So again, formation, there are quite a few detailed statutes about formation of an LLC, forming an LLC. You are required to register and form with the New Mexico Secretary of State. And the Articles of Organization is your main formation document. There's a lot of details in the statutes of what goes into one of those. And there's also ways to form those and make sure you're meeting all of those requirements online with the Secretary of State currently. Part of forming and also filing your Articles of Organization, you're also required now to file a registered agent statement, which is a statement of acceptance that your registered agent is accepting that they will serve as a registered agent. A registered agent in New Mexico it needs to be a person or a company that has a business that has a New Mexico address. And the whole purpose of naming a registered agent is for service, or one of the main purposes is for service of process, which is what happens if a lawsuit is filed. You want to make sure that you keep your registered agent address and contact information up to date so that that registered agent can be served and that you would be aware that there was a lawsuit or a potential claim being brought against you. So super important to keep those up to date. We've had some recent questions at the helpline about registered agents. And so there's just some major, the nightmare scenario where if you don't keep that address up to date, a lawsuit can proceed and a judgment be entered against you and a garnishment carried out from the company's bank account to satisfy the judgment that was entered against without an entity even knowing, because their registered agent address was not current. So very important piece. And then lastly, filing fee. Right now, it's $50 to form an LLC with the Secretary of State. If you meet all the initial formation requirements, then the Secretary of State will issue the certificate of organization. In addition to all of these documents, a best practice would be that you have a written operating agreement that again sets out how the business is structured, the members' responsibilities, how they meet, who's the officers, who is serving as an officer. Because otherwise you're defaulting to the statutes if a potential dispute or conflict arises, rather than having detailed in an operating agreement. And as you should have an operating agreement, it's not required that you file that with the Secretary of State. That can be a private document that's just held internally. Another big benefit of an LLC right now is there are no reporting requirements with the Secretary of State. I should have added that. With the Secretary of State, no reporting requirements as there are with other types of business entities. Larry?
So a couple of things I want to point out. The operating agreement is extremely important. It acts as a partnership agreement, by the way. And it varies drastically depending on whether you're member managed, manager managed, the type of taxation the company is. So I would encourage everybody to to not skimp on a high quality operating agreement. And here's it's, I'm not trying to plug my company, but we wrote an expert system that delivers a high quality document for $29. I don't care where you form your LLC or if you do it yourself, but for $29, you get a high quality operating agreement. If you don't want to do that, that's fine. You can download stuff off the internet, provided it matches how you're doing business. And I'll give you one example. Do a search for capital account. What is a capital account? It's a fairly arcane thing. I'm not going to explain it now, but it only applies for S Corp tax treatment. So if you're going to be a disregarded entity or you're going to be taxed as a C Corp, the capital account is irrelevant. You're looking at the wrong operating agreement. Look for another one. The other issue I wanted to bring up is that there's a lot of rules in this regarding like estate planning or what happens if you die, so on. And all of that is in the operating agreement, which is why it's so important. The other thing, New Mexico provides for anonymity, so you don't have to disclose ownership information, which is very beneficial for folks. And there was something else I wanted to say that I forgot, but LLCs are very popular. They're not very expensive. They're probably the most recommended entity type, even over corporations. And I thought of the final issue. If somebody tells you you want an S Corp, make sure you're talking to a CPA or other financial professional and ask them, do you mean a corporation taxed under subchapter S, or will an LLC taxed under subchapter S be sufficient? And if they don't know the difference, then it's probably an LLC. And you can go with an LLC taxed like an S Corp. And that will save you money and just be easier to manage and maintain in the long run. Thanks, Brecken.
Oh, yeah. Casey, do we want to take some questions about LLCs?
Yeah, you now are up to 9. So bearing that in mind, we have 21 minutes. So I don't know how much is left in the presentation, but just first question under the LLCs. How do we register a DBA under an LLC?
Do you know the answer, Brecken, or you want me to?
Well, my first gut reaction is that instead of registering a DBA as an LLC, you would be forming an LLC, and that becomes but I don't know if you form an LLC and then you'd like to do business as another name. I don't know the answer to how to register the DBA.
The answer is you file an amended articles of organization if it already exists. And if it doesn't exist, the name, you're just changing the name. The name's going to be the legal name. So let's call it company, LLC. And then you got to put the DBA name in the legal name in the articles. That's how you do that.
Okay. When creating an LLC, there was an option to upload a letter of consent. What is that, and do I need it?
I'm guessing that's the registered agent statement. I don't know. Otherwise, I don't know off the top of my head what that is. Larry?
Yeah, there's two types. The one could be the registered agent, maybe, or there's another one if you're trying to register the same name that already exists. You have to be the owner of the other company. And so you'd basically be submitting a letter of consent representing the other company that it's okay to form the new company that has the same or similar name. And it's not needed if you don't have a problem.
Okay. There are options for members, managers, and organizers. What is the difference, and what should I be as the owner?
So the organizer of the LLC is the individual or the company that is organizing the LLC. That's sort of the one-time designation of that. That's required to be included in articles of organization. You're going to have to name the organizer. But in terms of members or managers, that comes back to that designation are you member managed? Are you manager managed? And the only thing that I know of, Larry, is that you're required to make the designation. You're not required to provide to the Secretary of State the name of any of the members or the name of any of the managers. You're just required to make that designation in order to form So if that question is about formation and sort of the Secretary of State's website, I hope that clarifies that question. If the question is about whether you should be member managed or managed, that's a larger fact specific.
I just throw in a little bit. The owner is a member, period.
Right.
So that if you're an owner, you're going to be a member. And if you're a partner, you'll have members, plural, that have some proportion of the company. Managers don't need to be owners, but they could. And an organizer doesn't need to be an owner, but it could if the owner or member is filing the LLC themselves.
Okay.
Yes.
Next question, is being your own registered agent okay?
Yes.
Yeah.
Yep.
Legally it is. But if you're in a business, let's say we have abuse victims as clients. If they're their own registered agent, their public information is getting out there. And so I think it would, there's a business need sometimes where maybe you want to hire somebody else as a registered agent, but legally you don't have to do that.
Okay, next question. If husband and wife are one member, do you still split the operating agreement separate designations?
Can I get this?
Sure. Yep.
This question is confusing the issue of tax status versus ownership. So husband and wife are two owners, period. So whether it's John and Joe, they're not husband and wife, they're just two friends. They're going to own the company in some proportion. Husband and wife just get the benefit of a tax status, specifically because New Mexico's not common law. Anyway, it'll come to me. New Mexico is one of the few states that allows a married couple to be treated as a disregarded entity for tax purposes only.
Okay.
So
oh, sorry.
Go ahead.
When many of my clients, this is from Christopher Garcia, when many of my clients have an attorney or legal service set up their LLC, they often issue shares, have regular meeting, and take meeting minutes. Is this overkill?
This sounds like a little bit of a mix.
So one of the things with LLCs is we can create a mechanism called a unit, and it's very similar to a share. And some services don't make that distinction and will call unit shares, which I think is very poor practice. But an LLC can take on a more formal structure if it's defined properly in the operating agreement. So is it overkill? That's a great question. If it's done correctly, it's probably fine. And the more formality you introduce, the better in many instances. It allows people to deal with circumstances that might be might come up in the future. So more formality is great if they can manage to it, and they follow their corporate formalities. So I think it depends on the individual.
Okay, next question. Can you talk about the need of an operating agreement for a sole member LLC?
Single member.
You want me to tackle that, or?
Yeah, sure.
I'm sorry, I'm blathering. I can get some of these. I just deal with this all day long.
Yeah.
People don't know we do hundreds of LLCs a month. A sole member, you should have an operating agreement, period, whether you're a sole member or not. Why? In case a problem occurs. Now, a bank's going to want it, number one. So if you're going to get a bank account, you need it. If you're going to get a merchant account, you need it. But if something happens to you, the operating agreement can specify what should happen under certain circumstances. Finally, if you're sued, a good plaintiff's lawyer is going to ask for that. And they're going to try and figure out if you're not following corporate formalities and possibly try to pierce the corporate veil. So what I argue is a good operating agreement, whether it's a multi-member or sole member LLC, is going to help with asset protection and minimize liability for the owner or owners.
Okay. How do I get an operating agreement from Larry?
Am I allowed to post any URL at the end of this? Is that okay? Or they can call your office and ask as well.
Well, at the end of this will be a slide with your business slide in your business contact information so they can contact you. Yeah.
Yeah, that's great.
Okay. So we'll do that at the end. This one doesn't make sense to me, but maybe it'll make sense to you. If you have an LLC and put a DBA.
Yeah, I'm sorry, Carmen. That seems
Maybe.
like your question got cut off, maybe. I'm sorry, Brecken.
Maybe that goes to the other one we already answered about when you form your LLC and then you designate your DBA name as well.
Yeah, and I think Larry answered this one about using your home address for an LLC. That's, probably not great. Just thinking of the matter, we have like 12 minutes left and we still have the rest of the presentation. So I'm going to hold off on these questions. I think we need to get going on the rest of the presentation. And then towards the end, if we have more time, we'll get to the questions. Okay.
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 Works for me. Okay.
Whoops.
So.
Oh, there you go. Sorry.
Okay. So the next entity we have is a limited partnership. This is an entity that, again, has a bit more formality and structure, and takes a bit more effort to form it under state statutes. The structure of a limited partnership is an entity that consists of at least one, having one or more general partners and one or more limited partners. It's formed under state statutes. The general partner of the limited partnership has the authority to act as an agent of the partnership. You might remember from before, agents have the ability to bind the partnership, sign documents, etc. The general partner also has the equal right and or can carry out management duties for the partnership, just the general partner. And then the general partner also owes various fiduciary duties to the limited partnership. The limited partner, on the other hand, has no right or power to act or bind the limited partnership and only owes limited fiduciary duties to the entity, to the limited partnership. The risk and liability involved with a limited partnership, similar as I explained or as we explained before. A general partner of a limited partnership is jointly and severally liable for the obligations of the limited partnership of the entity. And the limited partner enjoys no personal liability, even if that limited partner participates in the management or control of the limited partnership. That was sort of the abbreviated version. Larry, anything?
I would just a quick one is this is not an effective structure for most business types. If you're thinking of it, you really talk to a professional first. There's probably a better entity for you.
Okay. Next slide, Casey. Forming it, there are requirements to form with the Secretary of State under New Mexico law. That mainly involves drafting and submitting a detailed certificate of limited partnership. If all the requirements have been met, then the Secretary of State will issue that certificate of limited partnership. Another best practice, if you're going to choose this entity, is to have your limited partnership agreement in place. Otherwise, again, the statutes govern. For limited partnerships, there are some non-waivable provisions, meaning you can't, if you draft a limited partnership, you can't waive away some of the requirements and obligations under the statutes. You can't say that those don't apply to your limited partnership. And again, if you do choose to do a limited partnership agreement, this is not required. That agreement is not required to be filed with the Secretary of State after you've formed and filed everything. Okay, last entity, the corporation. So a corporation is an entity structured that has a board of directors. The board of directors have the authority to manage big picture. They're sort of the upper level managers of the corporation that come up with overall strategy, that hire and fire officers, and directors are also elected, typically mostly by the shareholders, which we'll talk about also. The board of directors as well is able to form committees within the board of directors. So board of directors is one sort of layer of structure. The next layer of structure is typically officers. There's officers that serve at the board of directors' direction. They hire them and are fired by the board of directors. And they're more of the lower level managers who do the day-to-day, that carry out the big strategy that the board puts in place. A corporation also has shareholders, which are the individuals or entities that often buy shares in the corporation that represent their ownership interests. And often the shares and ownership interests that they have in a corporation that they hold also govern the shareholders' voting rights. Again, shareholders elect the board of directors that sort of direct the overall corporation. And then those shares also can impact the distributions that shareholders, that can be in the form also of a dividend, but the distributions that a shareholder receives if the board of directors approves those distributions. The risk and liability involved with corporations, the directors and officers have certain duties to the corporation. Again, in corporations, the idea of piercing the corporate veil can come into play if they take certain actions or are found to have made certain bad actions or decisions. They can be found to be held personally liable based on whatever that negative shakeout was. For a shareholder, their risk and liability in a corporation is limited to their investment. So the value of the shares that they hold, that's their limitation on liability. Larry, got a couple more corporation slides.
Yeah, no, I don't have anything to add at this point, other than it's a more formal structure. It's more expensive to set up, maintain, and take down. So it's not favored unless you have, advanced needs.
Okay. Forming a corporation, you form it again by filing a certain set of documents with the Secretary of State, articles of incorporation, a registered agent statement, again, super important. And then you pay a filing fee, depends on how many authorized shares you are designating that the corporation will issue. So $100 would be your filing fee for the first $100,000 shares. And then that filing fee goes up the more shares that you're going to have authorized. Again, if you meet the requirements, the Secretary of State will issue a certificate of incorporation. And then typically soon after you form, the board of directors that are named in those articles have the organization meeting, the purpose of which is to adopt bylaws, which are the governing document for a corporation. Very important.
And I would recommend that's legally required. A shareholder agreement is not legally required, but it's best practice and strongly recommended.
Okay. With corporations do have reporting requirements to the Secretary of State. So again, soon after they form, the corporation files its initial report and then files a report every 2 years based on a very complicated set of, based on the sort of end of your taxable year. So reporting requirements, corporations also, again, like Larry mentioned, have very detailed meeting and notice requirements. Shareholders meet annually, typically to elect the board of directors. They can also have special meetings. The directors have a little bit more flexibility, but they still have very stringent notice requirements when the directors are calling their meetings. Again, the idea of distributions when there is sort of net profit, net income that can be either invested back into the business, or if the board of directors choose, distributed through a dividend or some other form of distribution to the shareholders as a benefit. That is involved with a corporation. There are also other types of corporations that we're not talking about here. Nonprofits, S corps, Larry mentioned those briefly earlier, and then also a B corporation or a benefit corporation. Not providing more detail on those here, but other types of corporations worth mentioning. Okay. Given our time, I think I'm just going to recommend that this, just to have a good recommendation that you look at the Secretary of State's offerings on their website, on the business portal, and also under its business maintenance section. The Secretary of State really has a lot of functionality in terms of forming different types of entities, mainly forming LLCs. You can do that all online. You can also file your initial or annual reports or your biennial reports or other amendments into the business that's already been formed all online. So I definitely recommend checking out the website. For that, business licenses. Once you form the business, just note here that make sure that you acquire all the proper business licenses that you need to operate. That can be within your city or municipality or your county. Similarly, if you have a professional license, if you're operating as a contractor, for example, make sure you have all your licensing in order through the New Mexico Regulation and Licensing Department, or RLD. That's the state entity that oversees professional licenses, some of them, and more than just contractors. Next slide, Casey. Same thing. New Mexico Tax and Rev has a lot of information on their website, but specifically they also on their YouTube channel have really helpful videos of how to file and report your taxes, your GRT, and other types of taxes that you might need to file and report through their TAP system. So we recommend you check out their YouTube channel. Lastly, we have a few slides here about seeking further advice. So the Modest Means Helpline doesn't specialize in employment law. If you hire employees, you should seek advice from an attorney who specializes in representing employers to better understand other benefits, risks, and liabilities related to operating the business entities and employing individuals. Next slide. Modest Means Helpline also does not specialize in tax law and does not give tax advice. And in general, as a big governing rule of thumb, the type of business entity you choose has a huge, the type or what you're doing, what you're wanting to do, or how you're wanting to operate. You should definitely seek advice from either a tax attorney or a tax advisor, like a CPA, as it could be beneficial to understand if there could be entities that are, preferred or not that you form based on what you're wanting to do. A tax advisor could also provide you guidance as to whether or not you need a FEIN number based on the type of entity you are going to form. And lastly, is that we recommend that you meet with an insurance agent to determine the coverages that are appropriate for your small business. The risk associated with the goods or services you provide or how you're going to operate can definitely help you determine the type of entity to perform or to form. And then do we want to circle back to outstanding questions? Provide our contact.
Let's do that. Here's the slide. There was one question about contact information for the presenters. So here's the slide for that. And then the question is, last one is, can you talk about the umbrella LLC and New Mexico recognizing the different LLCs as separate entities?
Like or I'm guessing like sort of tiered subsidiary structure of an umbrella LLC. Larry, I'll let you take that.
So there's no such thing as an anonymous LLC or umbrella LLC. They're just all LLCs. And the question is, how is it being used and in what capacity? So when we talk about umbrella LLC, what that sounds like is an LLC that's not operating itself. Instead, it's owning other assets, such as maybe intellectual property or a house, real property, or maybe other companies. So if it's not operating, it has different set of liability issues and problems. And those issues and problems would roll up from whatever asset it happens to open. And so, or own, not open, I apologize. So it's, it is considered best practice for people that have portfolios, or maybe you have 2 or 3 different types of businesses and you want to operate them separately. And instead of having 3 different taxes for each company, you can have an umbrella at the top and all the profits and losses flow up as disregarded entities to the umbrella entity. So there's a lot of advantages depending on what your specific needs and issues are. But you got to be careful because S corps can't be owned by S corps. I'm talking about tax status. So if you wanted to tax your individual operating entity as an under subchapter S, you can't have a subchapter S entity be the owner. It has to be a disregarded entity. So there's some tax dimensions to this to get it correct.
Okay, great. Well, we don't have any, there was one other question, but it was pretty fact specific. So I just recommended the person call the helpline. Any other, oh, there's one more question real quick. Larry, did you want to say something?
I just say thanks to Christopher. Yeah, I couldn't think of community property state because I had a brain fart. New Mexico is a community property state, and that's what the IRS permits to allow husbands and wives to look like a single owner for tax purposes only.
Okay, thanks, Chris. I think I erased you because I was like, that's not a question, that's a statement. What are you talking?
Okay. Well, if we don't have, again, here's how people can contact the Modest Means Helpline. Larry's information is here as well. And he does have a great website. So do look him up online. And yeah, if you have further questions, please reach out to the Modest Means Helpline. And if you have ideas of further topics that you'd like to see in our small business webinar series, please be in touch as well.
And thank you to the Modest Means Helpline. You guys are doing great work. Thank you.
Thanks you.
And our co-presenter, Larry. That was great.
Oh, we have one other question.
Okay.
I don't know if we want to take it.
Great.
An LLC can have several DBA, but run under the same LLC. Is trademarking a major issue?
I'll answer and say trademarking is a major issue. I don't know if it's the major issue, but you definitely are not permitted to infringe on other people's trademarks. So I get all the time, well, I put my company's name is Disney LLC. Why can't I use Disney to promote my animations? And, it's just, and I know that's a silly, crazy example, but that's the strength of trademark law. So you have to be very careful. Great.
All right. Well, thank you, everybody. And be on the lookout for future webinars. We'll be doing these again, we'll be doing 2 more before June 30th. So we'll be getting all the information to all the small business development centers and West and the other groups that we're in touch with. So thanks again.
Thanks,
everybody.
Thanks, Larry. Bye.